Hello everyone, welcome to our data protection series. My name is Lazarus. I'm a data protection and technology lawyer in Nigeria, and I regularly provide actionable insights on compliance with data protection requirements in Nigeria. If this is your first time joining, kindly subscribe, like and turn on your notification so you don't miss any of my episodes. Okay, in today's episode, I'll be talking about the scope of the Nigerian Data Protection Act 2023. Data protection compliance has become a major issue for many businesses all over the world, with the serious enforcement of data protection laws in Europe, in America, and in Nigeria. So that has made most organizations to become conscious on how they process and use customers' data. So the Nigerian Data Protection Act was enacted in June 2023. And from that date, all organizations in Nigeria have specific requirements and obligations to comply with the requirements of the law. And which organizations or persons does this law apply to? First and foremost, for us to understand the scope of this law, we have to understand what personal data is, because the law applies to all processing of personal data in Nigeria. The Act applies to processing of personal data, and for us to really understand what this is, we need to understand the meaning of personal data and the meaning of processing. So, coming to personal data means any information relating to an individual who is identified or identifiable. It could be the person's name, it could be the person's email, address, phone number, state of origin. Anything that relates to any human being that can be identified is personal data. So the law is very broad on what personal data is. So you should be very careful when you are collecting people's information and data. If you are doing that, the law applies to you, and there are various obligations that you must comply with in order to do that. Now, the word processing, as used, as we said earlier, the Act applies to the processing of personal data. What is processing? Processing simply means anything you do with someone's personal data. It may be collection of the information, it may be storage, it may be analysis, it may be sharing it. Anything you do with personal data amounts to processing. So, in addition to processing personal data, which comes within the scope of the law specifically mentions that any person or entity or organization that is in Nigeria, they must comply with the provisions of the law. If another one is that if the processing activity takes place in Nigeria, it must comply with the law. Now, does that mean that foreigners who process personal data of persons in Nigeria don't need to comply with the law? The answer is no, because the law went for that to state that any processing of personal data by entities outside Nigeria, but that personal data relates to people in Nigeria, then the entities outside Nigeria must comply with the law. To sum it up, the Nigeria Data Protection Act of 2023 applies to any processing of personal data. And if your organization is in Nigeria, or if your organization is operating in Nigeria, or your organization is processing personal data in Nigeria, it must comply with all the requirements of that law. And even if your organization is not in Nigeria, but you are processing personal data of persons in Nigeria, individuals in Nigeria, then you must comply with that law. For example, due to the advancement of technology, we have Nigerians who are in Nigeria but are working for companies outside Nigeria. And for that relationship to really work, the companies must have the name and address, email address of people in Nigeria, pay them with their bank accounts in Nigeria. So that type of handling of their personal information must comply with the Nigerian Data Protection Act. Why should you be concerned with what this law is all about? First and foremost, if you do not comply, there is a penalty for it. The penalty for non-compliance is 2% of your gross revenue for the preceding year. And if you are regarded as a processor, a data processor or controller of major importance, you can pay 10 million naira, or if you are not regarded as a data controller of major importance, you can pay 2 million naira. So the penalty is actually 2% or 10 million naira, or 2% or 2 million naira, depending on your category of your organization. So the penalty is not just the only consideration that you should take in while deciding whether to comply or not. Consider your customers. Consider their confidence and trust in you. So if your customers trust that you handle their information with care and in accordance with the law, they can trust you with that information. And if they don't trust you, they may not want to deal with you because they don't trust your data protection practices. So this is just in summary the scope of the Nigerian Data Protection Act. And in subsequent episodes, we'll be talking about the specific requirements as to how you should go about with complying with the law. This brings us to the end of today's episode. If you have not subscribed, kindly do so. I will see you in the next episode.